Welcome and thank you for joining us at Arizona is Reopening for Business. We are going to go through a lot of material today. Very much appreciate you joining us. We have decided to give you grand materials. Everybody can have this PowerPoint. It will be available on our website after the seminar. If you need it quickly and can't get it off our website, shoot me an email and I'm happy to send you an actual copy of the PowerPoint. As I said, the materials have a lot of information. We are going to spend the hour we have together today going over the questions we seem to be getting most from clients that are the tricky issues that keep coming up. So please forgive us if we cover some things fairly superficially. We really do want to spend our time on what we feel like will be the questions that you're all getting. We are applying for CLE for any attorneys who are on the phone and HR credit. For any HR folks who are on the phone. For those of you who don't know Lindsay and I, we do employment law. We spend a lot of time in the courtroom, and that's what the focus of this is as well. We want to keep you out of the courtroom, or if you find yourself in the courtroom, we want to give you the best defense you can possibly have. Our friends in the plaintiffs bar are already out there not only filing lawsuits, but thinking up new ways to file lawsuits based on everything we're seeing with COVID-19. So the real focus of this is intended not to be political. We understand that this issue has become incredibly politicized. People feel very, very strongly about it one way or another. And we may have some of those feelings too, which hopefully will not come through. What our approach is we want to keep you out of trouble. We want to keep you out of court, and if you find yourself in court, we want you to have the best defense. That's where we are coming from. So with no further ado, this is our agenda today. We're going to first go through some general considerations for workplace reentry. You've all heard, by the way, Arizona's reopening. I hope that's not a newsflash to anybody on this. Arizona is reopening salons and barbershops on Friday, which, yes, we're all very happy about that to the extent you feel safe going to those places. Restaurants are going to open on Monday, as well as retail. A lot of the regulations and requirements of the original same shelter-in-place order have been lifted with regard to those industries. So we're going to talk about these different things. We're also going to do an FFCRA refresher. We're going to go over some general workplace safety ideas, and then we're going to hit the WARN Act really, really quickly and go straight into Q&A. Lindsay.
Yes, thank you. As Stephanie mentioned, well, maybe not most, a lot of states are either lifting or starting to lift their shelter-in-place orders. Some states are doing phased-in reopenings. Arizona, as Stephanie mentioned, is reopening many businesses on Friday and then restaurants on Monday. One of the things that we wanted to talk to you all about today is how to prepare your workplace if you have been closed or if you have had limited employees, skeleton crews, and whatnot. How to prepare your workplace for reopening more fully or completely. We're going to talk about preparing for that reentry, some issues that have come up with returning employees specifically to the workplace and how you do it, and then issues to consider for the post-reopening phases. Preparing for workplace reentry, there's a lot of different guidance here, and I'll go through this. You've got it all here on the slides, so I'll just kind of hit the high points. But essentially, developing a task force or a point person or people for developing a plan and communicating that plan is important. Rather than employees getting information from all different sources or rumors flying, having a point person is important. And also having a plan in place prior to the reopening or the rejoining of many employees to the workforce so that issues are thought of in advance. And some of those issues include creating a cleaning or disinfecting schedule. What can you do to keep your workplace as safe as possible, to encourage social distancing, to keep it clean? Think about changes that you can make to the physical workplace that would promote or help social distancing. That would include things like closing the break rooms or having signs that say only one person at a time. Same with the bathrooms, signs that only one person at a time should enter if it's a communal space, excuse me. Consider whether you can reposition some of the workstations or put barriers between cubicles that would allow people to have that 6 feet of distance. Consider changing or altering schedules for your employees so not everybody is showing up or leaving at the same time, all trying to cram into the elevator. Those days perhaps, maybe, hopefully are over for good. I've been stuck in an elevator with multiple people, not fun, and especially not fun during this time. If a meeting can be held via phone or video, you should do it. Limit visitors in the workplace. Try to eliminate in-person events if possible. If you have to have face-to-face meetings, they should be as short as possible and involve as few of people as possible, and in a space big enough, if possible, to allow the people who are there to be 6 feet apart. Consider also other types of signage or markings you could include on the floor, taping out. We've seen on the grocery stores or Walgreens the 6 feet apart guidance for employees or other individuals entering the workplace. Consider providing protective gear for your employees and hygiene supplies and giving them instructions on how to properly use these items. This would include face masks, for example. There are some states and local governments that are requiring employers to provide face masks. For example, in Colorado, restaurant employers are required to provide face masks to all of their restaurant workers. We're
hitting on that. Let me interrupt Lindsay right here. We're hitting on this for a reason. Masks have become a very political issue. And Ducey, here is Ducey's executive order, which was lovely. We have a couple links later in this presentation that you can click on that go a little further in saying what the governor's office is suggesting with regard to restaurants and barbershops. And he does not go so far as saying masks must be worn. And so again, I want everybody in the back of their heads to think, who is going to end up being sued? And the people who are going to end up being sued are people who are not doing the basic things. And the other thing I want you to think of too is you've got all different levels of sensitivity in your employee workforce. You've got people who think this is a total hoax, are going to come back, are going to not want to do anything. And you've got folks who are legitimately frightened about what may happen to them or someone else in their household. And so masks are something that you certainly can choose to have. You can choose to require your employees to wear them, even if Arizona is not saying you must do this. It certainly is our advice that it will help you later in any kind of litigation you get into if you have told your employees to mask up. And so consider that. Consider doing that regardless of what the government is ordering you to do.
Yeah, on that note, I mean, you want to be able to say that you did everything that you could do to keep the workplace safe within all the guidelines that have been provided and even going some of these extra steps. But what do you do with an employee who refuses to wear a mask and you decided it's necessary for safety? You know, I mean, you need to consider at that point if there's a medical reason that might be causing that person some concern. But to the extent there isn't, an employee is just being insubordinate, you may prohibit them from the workplace or even terminate. Also, really important, hand sanitizer, soap, disinfecting wipes. Yes, we brought props today. Have that all over the workplace, especially in the restrooms, especially in the break rooms, especially in any other communal areas. In addition, you want to think about whether you're going to implement testing or screening for COVID-19. Employers are considering, for example, testing temperatures of all individuals, employees, or the public who enter the workforce. Obviously, encouraging employees to self-report is really important and reminding employees, and we'll get into this in the workplace safety section, but you know, really hitting home that employees who are sick should stay home. Right now, the EEOC has said it is okay to test employees, to test new hires, to test current employees, and for now, that's fine. Stay tuned on that to the extent that it changes. You'll probably hear from us again. But 3 things to really keep in mind if you are going to test or screen employees for COVID-19 or its symptoms. To the extent you keep records of the temperature that an employee tested with or other symptoms that they're experiencing, those need to be kept separately from their personnel file and in a confidential location and manner. You should never disclose the name of an individual who's tested positive for COVID-19. In addition, if you're not testing your entire workforce and you're only testing certain people, it needs to be the reasons for testing some and not others really need to be based on legitimate reasons. Perhaps you're only testing those who have whose job requirements or whose job duties require them to interface with the public, but it needs to be done consistently. And then third, to the extent you have non-exempt employees, those who are typically paid on an hourly basis, standing in line waiting to be tested before they can enter the workforce, you need to pay them for that time. Some additional thoughts about preparing the workplace, considering how to handle employees who are refusing testing or refusing to wear the masks, as we mentioned. There may be exceptions for employees who have legitimate medical or religious reasons for not wanting to be tested, and considering whether there are reasonable accommodations available for those folks. Review your policies. Just because we're reopening for business, as they say, doesn't really mean the pandemic is over in any meaningful sense. All those paid leave laws that went into place in April are still very much in play. And there are still lots of new cases every day, and you're likely to have employees who are going to need that leave, especially if you've had employees who are furloughed or not working right now and are coming back. They are now eligible for that paid leave. And so reviewing your policies will be important. Consulting legal counsel to ensure you're in compliance with the state orders and local guidance, as this is constantly changing.
All right, so you're really getting ready to bring the folks back. If your business allows you to return people in stages, it gives you a lot more flexibility. It gives you a lot more flexibility because what you're going to find is you have some people who don't want to come back. That's what a lot of my clients are finding right now. It's when they just say, hey, we're reopening on Monday. Please let us know your availability ASAP. They have a number of employees who are saying, I don't feel comfortable coming back to the workplace. So if you are going to open in stages and incremental stages, that gives you the ability to leave some of those folks on furlough or RIFT or on the sidelines a little bit longer. So really do think about doing it in stages. Regardless, do have a neutral, non-discriminatory business justification for the order in which you're returning employees, and keep documentation of that. Yes, my middle name is document. But please do, because when these lawsuits come down later, a lot of these decisions are being made very, very quickly. Just email yourself if you don't have anything else. If you can too, because of the issue that I raised earlier, that some people just don't want to come back, consider making the return voluntary initially. That gets you over a lot of these issues if you just allow people who really don't want to come back to opt out. And your HR and benefits folks should sure be ready to address a bunch of issues. How is this going to affect my health benefits if I don't return? Where is my PTO? Where is my vacation? Can I use that now? All of those questions are being asked regularly. You want to send out a return to work notification. And here's some ideas for things to include. And then you want to get ready because you're going to have employees say, hey, I really enjoyed this working from home. Can I just keep doing it? And a lot of you who are on this presentation, we've already had these calls about how difficult it's going to be now to say these jobs cannot be done remotely when they have been being done remotely for the last 6 or 7 weeks. So look at those things, but get ready for them. If people are requesting leave or certain accommodations, get ready to hear those and don't just automatically dismiss them. Again, I think as Lindsay hit on later, some employees will raise safety concerns. I don't feel safe coming back. Some of their concerns may rise to a level of a legal protection. So make very, very clear if you're taking any kind of action, it's not because they voiced a concern, it's because they're not coming back to work. We're going to hit on this a little more in a minute too. These are really the questions we're getting. And so I created several different buckets. What do we do when an employee doesn't want to come back? First of all, just saying, I'm afraid I'm going to get coronavirus is not a legally protected reason. But that bucket, we have to make sure the employee's really in that bucket. So you want to follow up with the question of, tell me why. Tell me why, what your concerns are. And if the person says, when I was a child, I had cancer, I have a compromised immune system, then really what they may be saying to you is, I need an accommodation of additional leave time. Does that count as FMLA? Maybe. How about my child had cancer and I can't go back to work in a restaurant and be exposed to corona and bring it home to my child? Is that a request for FMLA leave? How about FFCRA leave? Does it fall into that bucket? And keep in mind too, now that the employee's coming off furlough, FFCRA and FMLA are back in play. If an employee says my child care provider is not available or my child's school is out, I can't come back, again, FFCRA reasons. So make sure when you're talking to employees who are indicating hesitancy to return or refusal to return, you're really drilling down and understanding what they're saying. And as much as this is all going to drive you crazy, I really want as much of this documented as possible. Because what we're hearing from our clients is a lot of people are saying, number one, and I don't want to get a year down the road in the middle of their lawsuit and find out that oh, no, I told the HR person it was number two. So make sure you're getting this documented. Either keep really, really good notes or do this via email or do it in some other way that you are documenting what the employee has said. Okay, what about unemployment? This is another huge issue, and I will tell you, I have spent no less than 8 hours, I wish I were kidding, my eyeballs are bleeding, on the DES website trying to figure this out. And y'all, DES is doing a heroic job. They have had 500,000 new applications for unemployment, 500,000. And this is an agency, and I am going to give a political opinion, this is an agency that historically is underfunded. And understaffed, and those folks do a great job with what they've been given. And I know Governor Ducey is throwing a lot of money at them and a lot of resources at them, and they've done a great job. And there's a lot of information about how they're treating COVID-19 for unemployment benefits. So let me kind of walk you through what I found on their website. While people on unemployment are no longer required to be actively seeking work, they can be disqualified for not being willing or ready to accept work, or refusing a genuine offer of suitable work without good cause. Now, I dug into that a little bit, and the DES instructions that are on the weekly form that an employee must fill out to continue getting unemployment asks the person, have you refused any job offer or referral of work? If the employee believes the job offer put that employee at risk of exposure to COVID-19, they can answer that question no. What I'm telling employers is this is not, what the DES ultimately decides to do with that employee is not for us to advise the employee. The employee needs to do whatever they need to do that is between the employee and DES. But I do want you as the employer to understand that I think this is a gray area and be really, really careful about making any representations to employees. It is difficult, and we are getting some employees who say they don't want to come back to work because they're making more right now on unemployment. In Arizona, the benefit before the CARES Act was a minimum of $117 to a maximum of $240 a week. CARES added $600 a week to that. Now the last payment will be made July 25th. The DEA's got really slick procedures now. Everything is done electronically. You get a card, and the last $600 payment will be made the week of July 25th. And that you can tell employees, and unless Congress acts, and Mitch McConnell has already made it very, very clear that it will be over his dead cold body that this gets changed. But at the end of July, that $600 will run out. Will an employee who refuses to return to work still be eligible for unemployment? Again, it depends on the state you're in. I know everyone on this webinar is not in Arizona. It does appear that the DES will at least consider COVID-19 related reasons. although it's not absolutely crystal clear. And I know our DES is working on more definitive answers, which may take some time to play out. But in any event, that's unemployment and the reality all of you employers are dealing with, particularly with lower wage employees. All right, so post reopening, develop a communication plan. Make sure you're communicating with employees regularly, and again, reminding them in every communication, make it the tagline on your HR folks' emails. If you are sick, stay home. Hopefully people still have enough benefits that they're not suffering any financial penalty to stay home if they're sick. Remind employees if you have any of these symptoms, fever, cough, lethargy, if you have any of the COVID-19 symptoms, please stay home or talk to us. And make sure you continue to monitor the workplace. Lindsay, we're going to get in a little more to temperature testing, but I know a lot of the hospitals and other businesses out there have not only done temperature testing for employees, they have put in scanners that scan up anybody's body temperature.
Thermal imaging.
Yeah, thermal imaging. So they, boom, you test 100 or over, and they pull you aside and let you know. Prepare for potential spikes in absenteeism, cross-train, and consider the health guidance. CDC and OSHA, the World Health Organization, there's lots of good information out there. It continues to roll out, by the way. More on this shortly.
I'm just going to give you all a quick refresher on the Families First Coronavirus Response Act, the paid sick leave, and the expanded FMLA that was provided by that act, and some frequently asked questions as employees are returning to the workplace about this law. Stephanie.
Oh, sorry, we got to speed it up too.
Thank you. The law applies to businesses with fewer than 500 employees. There are some exclusions. Businesses with fewer than 500 employees can opt for an exception when the employee is asking for paid leave for childcare reasons. There is family medical leave, paid emergency leave, and enhanced unemployment insurance under this law, which went into effect on the 1st of April and will be in effect until December 31st, 2020, at least as of now. Paid sick leave, these are the 6 different categories that an employee can fall into in which they're eligible for up to 10 days of paid leave at a reduced rate. Really important, employers can get a tax credit when they provide paid leave to employees, but there must be documentation to support it. Most of this comes in the form of some kind of doctor's note or other sort of like a quarantine order or a school closure email or a note from a child care provider that I refuse to continue providing services until this is over. Those are examples of some of the documentation that it will be really important for the employer to maintain to get the credit. In addition, there's paid emergency FMLA, 12 weeks, up to 12 weeks for employees who are unable to work either at the job site or remotely because of childcare obligations where the school has closed or the childcare provider is unavailable. Again, documentation is super important here. Documentation for childcare reasons is a little bit different. What employers should really look for is information on the name of the child that is being cared for, the name of the school or the place of care that is closed or has suddenly become unavailable, and then some sort of statement affirming by the employee that there's no one else available to care for this child. Important question we're hearing a lot. Employees who are returning from layoff or furlough, are they subject to the 30-day waiting period? So the law originally said that employees would not be eligible for EFMLA unless they have been employed for 30 days. What about employees who've been off for at least that much amount of time? They do not have to wait for eligibility for EFMLA leave. They are considered to have been employed for 30 days if they were let go prior to December 31st, 2020, and had been on the payroll for 30 or more days during the 60-day period immediately preceding the termination or layoff. Important to remember that FMLA, our good old trusty friend, regular unpaid FMLA, may still apply to a lot of these situations. If someone has used up their 10 days of paid leave to care for themselves because they have COVID-19 or COVID-19 symptoms, and they're not ready to come back, they may be eligible for unpaid leave under the FMLA. Similarly, caring for family members who are experiencing COVID-19 or its symptoms, they may be eligible for FMLA for that reason as well. Consider, of course, whether the employee is also entitled to paid sick leave under other municipal or state laws. California and Arizona both have paid sick leave laws. The FMLA runs concurrent with the FFCRA leave. And it's important to know that employees are only entitled to 12 total weeks in a 12-month period. So if they use 10 weeks for COVID-19 reasons and have a baby later in the year, they've only got 2 left. Also consider pregnancy and ADA considerations. There may be an obligation on the part of the employer to reasonably accommodate individuals who have medical conditions that make them vulnerable to COVID-19 symptoms. Maybe, as we mentioned before, employees who are asking to work from home or continue working from home. There may be employees with medical conditions who don't want to return yet, or they want to go on an unpaid leave. Think about also accommodations for employees who are pregnant. As we've now mentioned a few different times, it may be very difficult going forward to say that it's not a reasonable accommodation to allow an employee to telecommute when they have been doing it for a number of weeks thus far. Some other questions we're getting a lot of: what happens when an employee exhausts their EFMLA, which may happen? That person needs to return to work at that point, unless they qualify for leave under some other law as an accommodation under the ADA, or if they have other time off available to them, or there are other unpaid leaves available under the employer's typical policies that may apply. If there aren't any of those situations available or any of that leave available, additional time off can be denied. What if an employee asks for EFMLA because the child's school is closed, but it's during the summer when a child's school would normally be closed anyway? The school closure in that case would not make the employee eligible for EFMLA. But remember, if the employee would have had childcare lined up for the summer, but for COVID-19, then that is a basis for taking leave under that category. What if an employee uses up their paid leave to take care of a family member and then the employee gets it? They don't get an additional 10 days of leave. It's 10 days total for any one of those reasons that were discussed on the earlier slides. But again, remember that there are paid sick leave state laws in place. Arizona, California, many of the West Coast states and cities have these laws, and stay tuned because many other states and cities are working to pass those laws as well. Do I have to allow an employee to continue working from home after we reopen? I think we've now answered this question 5 times.
Maybe.
But maybe. Yes, it depends. Really consider whether it might be a reasonable accommodation. And again, think about whether it's really, if you can plausibly say with a straight face that it's an essential function of the job to be at work when the employee hasn't been at work for so many weeks. What about an employee who doesn't want to come to work because they're worried about the workplace being infected? We've talked about that. That's not a basis for leave, but there are other ways to handle that, as we have discussed and will in some slides coming up here. Enforcement is starting. The Department of Labor said that we are going to issue a temporary non-enforcement policy to allow employers to get up to speed with all of these new laws. That ended on April 17th. And 6 days later, the Department of Labor issued a news release in which they had explained that they had already found a violation. So they are moving quickly on this. There's some information here about an employee in Tucson who essentially was under a quarantine order by a doctor, and the company did not pay him for sick leave. I put this quote from the Arizona District Director up here in big letters because it's, I think, a nice reminder that the Department of Labor is looking at all of this. And he has said this should serve as a signal to others that we are on it and you better beware. There's also a lawsuit that's been filed. As far as we can tell, the first lawsuit filed under the FFCRA A few weeks ago, there was a woman who was the director of revenue management at Eastern Airlines. She, according to the complaint, had an 11-year-old son whose school was closed because of COVID-19. She was working remotely and asked for 2 hours of time per day to deal with her childcare issues. She didn't have coverage. And she specifically asked for paid leave under the FFCRA, and it was not provided. And you can read through this for yourselves. I've copied and pasted some quotes from the complaint because the plaintiff herself copied and pasted email exchanges that she sent back and forth with her employer. And I put this here because it sort of solidifies the advice that we often give folks, which is you should write every email as though it's going to be Exhibit A to someone's lawsuit someday, in which this was. She was denied the leave and then she was fired 2 days later. She's alleging a bunch of claims under the FFCRA, interference and retaliation against the company and some individuals.
Again, remember when you are writing these emails that they are going to be read by a judge and jury. And if you just write them for a judge and a jury, they'll be just fine. These were not. All right, workplace safety. Do you have to report it to OSHA? OSHA first said, yes, we need to have you report these. Please let us know. And then a couple of days later, I was just like, no, stop, please. We've had enough. So if you're in healthcare emergency response or a correctional institution, you have one standard. If you're a normal employer not in those industries, unless you have objective evidence that this is work related, OSHA doesn't want to hear about it right now. The evidence would be there are 20 people in one of your departments who all tested positive. Something like that, then OSHA wants to know about it. Keep in mind that we're not telling you not to report this, but it may have ramifications in other areas. It may have ramifications on unemployment or workers' compensation claims. It may have implication in negligence lawsuits. So take OSHA's guidance to heart, which is if you're not in healthcare emergency response or a correctional institution, you need to have evidence that it really was work related.
By the way, just a quick interruption here, because I've seen a couple questions pop up. These materials will be available. If they're not already on the website, they will be on the website immediately following the presentation. So you'll have all of this to look back on.
Or just email me at stephanie.quincy@quarles.com and I will shoot you the actual PowerPoint, which you can take our logos off of and use at will. Workplace safety. These are things to think about. And again, I want you to think about lawsuits that may be coming down the pike. I mean, I would also like you to think, let's keep all of our employees safe. Let's keep all of the guests in our buildings safe. But to the extent you need to justify this to somebody who may think that these are all unnecessary, these are things later that if somebody, God forbid, gets sick or dies, you want to be able to say you were doing everything you could. First and foremost is telling people to stay home if they do not feel well, and making employees really able to do that by having generous sick leave policies where they can stay home without financial consequence, certainly can stay home without job consequence if they're not feeling well. Enforce distancing in the workplace. Tell your teams no more face-to-face meetings. If we do need a face-to-face meeting, we want the minimum number of people for the minimum number of time. Everybody should be sitting at least 6 feet apart as we are here. No meetings in break rooms or bathrooms. Some clients, as Lindsay said, are closing break rooms. Discourage using public transportation. I understand that's a tough one for folks who are in larger cities like Chicago and New York. Even here in Phoenix, we have a lot of employees who ride the bus. New York, if you look to see what they're doing with the subways, they're doing that for a reason. Right now, the experts are opining that some of the spread in New York may have been due to the subways. And if you go back and look at photographs that were taken when this started and everybody is packed in these subways, even with masks on, that may be a way it is spread. So discourage the use of public transportation. Tell people to, have someone in their family drop them off. Obviously, some employees are still going to be using that. You may want to tell those employees to bring a change of clothes, make sure they wash their hands when they get as soon as they get to work, to use sanitizer and wear masks, have a different mask to put on, different gloves when they get to the workplace. If you have cubicles, separate people. Again, what Lindsay said with job staggering, where you don't have everybody coming in at 8 and leaving at 5. Maybe you've got a morning shift, maybe you've got an afternoon shift. Do what you can to space people apart. Masks, my recommendation is every workforce should be wearing masks unless you are in a closed office like this one is, or doing something like speaking in a presentation that really requires some people to be able to see your mouth, read lips or whatever. Masks should be used. Gloves is more of a question. It depends on your workforce. It depends on what you do, but certainly consider gloves, especially a pair of gloves people can pick up when they're leaving the building and in an elevator or going down a nasty escalator or whatever. Regular cleaning, obviously, must be done. What do I do if I have an employee who reports a COVID-19 diagnosis? Verify this first. Make sure the person actually has it. At the beginning of all of this, and it's still going on, we have people who are just sure they have it, and then they go and get tested and they actually are not positive. If you do, and you'll want this in your policy, your return policies, you'll want to communicate to the general workforce that there has been a confirmed or likely case of a coworker with COVID-19. Tell employees to monitor their own health symptoms. Then you're going to want to separate out who had direct contact with that employee. Prolonged contact within 6 feet with the infected employee in the last 48 hours. Those folks you should pull in and tell them directly that this has happened. Again, you can't disclose the identity of the employee. It may be obvious, if you've got 4 folks in your office and one of them suddenly isn't there anymore, it's going to be pretty obvious what happened, but don't identify the person. That's protected under the ADA. This is basically the same way. Oh, what do you want to do with folks who are not employees? Employees who are directly affected, let me go back and hit that again. You can make a choice as to what to do. Anyone who is in direct contact with them within 48 hours, within 6 feet, should be sent home for 14 days. They are likely exposed as well. And then you need to answer other questions like, what should you say to the public, guests, customer, vendors? The CDC has guidelines for cleaning. All of the questions about what you say to third parties is going to be based on the individual circumstances of any situation. When can an employee diagnosed with COVID-19 return to work? Actually, just last week, the CDC changed this guidance. It used to be no fever for 72 hours, or other symptoms have improved, and at least 7 days have passed since their symptoms first appeared. The CDC changed it last week to 10 days. Information keeps coming in that asymptomatic people are carriers, and there really is no good information on how long someone sheds the virus. So these are the new CDC guidelines. Do try to follow these to the T, because I think this is going to be in a closing argument somewhere, and perhaps even in a jury instruction somewhere. What if an employee says they may have been exposed to the virus? Ask questions, get the specifics. Not every claim of exposure is a legitimate concern, but many are. You should if you believe it's a legitimate concern, the employee should immediately be isolated. They should be sent home, and then you're going to follow the guidance for informing coworkers and third parties and following the CDC guidance on cleaning. Can I tell employees that they can't come to work after they report someone in their household has COVID-19 symptoms? Yes. The CDC recommends that employers keep employees out of the workplace until at least 3 days after the affected individual has a fever, the respiratory symptoms have improved, and it says here 7 days. That should be changed, cross that out. It should be 10 days since the symptoms began. So yes, if somebody has someone positive in their household, it is very likely that they will be getting it too. This is a highly communicable disease. And so you would be wise as the employer to remove that person from the workplace. The real question becomes, do you need to pay them? And go back through the prior slides. Can we require employees to submit to a temperature test before coming into work? Yes. And this is one thing that in my closing argument in defending you, I want to be able to say you are doing. Many employers are doing this. Some businesses are doing this even for guests. I actually saw a restaurateur interviewed on national news, and he was in Texas. He's testing all his customers. He's keeping a list of every person who came into his restaurant. So if anybody tests positive, he can personally contact them and tell them. That may be the gold standard. I'm not suggesting that you do that, but this is certainly something that you want to consider doing. It's relatively easy to do. And here are the different tips for doing it. Can we require our employees to wear face masks at work? Yes. If you're going to require it, you need to provide the masks or pay for them. It's much, much, much more preferable to just provide the masks for employees. And it's a best practice to require everyone in your facility to wear them. And some states right now have gone this far. Some states that are hot spots, New York, for example, you can't go into a store without having a face mask. You can't walk on the street without wearing a face mask. But also train your folks, and all you have to do is a simple little email. You can get these on a bunch of different websites about what to do with the mask, because otherwise, you know, they're really mostly just for decoration.
We have a question related specifically to masks, so I thought this might be a good time to address it. An employee has asked not to wear a mask due to a skin condition, but we have made mask wearing mandatory. How should we proceed with this employee's request?
I would really try to get the information about what condition the employee has and see if the employee's healthcare provider knows of any masks that may be less impactful to her. There's a million different kind of masks out there, and we're not talking about medical grade masks. I don't know if you're a healthcare provider, and if you are, the answer is going to be different because obviously you are going to be using medical grade masks. But I would definitely enter the interactive process with that employee and see if there's a way around it. But if you're requiring that mask, you certainly can tell her what we will give you as a reasonable accommodation is a leave of absence, or we will allow you to work from home. But do check and see if there's any kind of mask she could wear that would not have as much impact on her condition. What if my employees don't want to come to work? Y'all, this is hard. It's happening. It's out there. And there are people who really legitimately feel this way. Again, we went through the slide where we've got the buckets. I would not make someone asked me a question earlier, you know, can we just tell all of our employees over 60 that we're not going to return them? No, let's not do that. But if somebody approaches you and says, because of my age, or because I have diabetes or asthma or some other health condition, I don't feel like I can come back, you need to consider those individually. And if there is a way you can put them in a bucket to return them later at their request, that certainly is one solution. You may need to get creative and work on other solutions. And again, we talked about people potentially being whistleblowers. But the other thing I really want to encourage you to do is listen to what your employees are saying. Some of them have really good ideas about solutions to social distancing in the workplace, solutions to precautions and protective equipment in the workplace. So listen to what they have to say. They may have a good idea that you can actually use. Here are some guidance. I'm not going to just read these slides to y'all. Here in certain industries, OSHA has put out guidance. Here's some. Oh my gosh, workers' comp, this is so interesting what's going to happen. And there's a whole bailiwick on this. Can employees who experience COVID-19 symptoms pursue claims under the workers' compensation system? Okay, first of all, you better hope so, because workers' comp is there for you. Workers' comp was developed by employers so they would not have to pay punitive damages and other huge, enormous damages and negligence actions. That's what that system is for. Right now in Arizona, the burden would be on the employee to show that they contracted it at work, which is also why we're telling you this. If you're doing all these safety things, it's going to be less and less likely that the employee contracted it at work. These are the questions. If an employee sustains an injury in and out in the course of their employment and it was accidental, even if it was negligent, it's covered by workers' comp. If it's arising out of the course of their employment. Intentional acts are not covered. And there has already been a lawsuit that we're going to talk about filed against Walmart in Illinois by a man who died. He worked at a super center. 2 employees died there. And his family has already sued Walmart saying this was willful, this was wanton, you didn't do the basic precautions, you didn't provide gloves, you didn't provide masks, you didn't require temperature checking.
You didn't train your employees on any of these issues.
So this is why we're saying it, is we don't know how all of this is going to shake out. So doing all of these precautions is going to put you in a good place. Already a lawsuit filed against a cruise line that was not doing these things. Already a lawsuit filed against a hospital because a security guard wanted to wear a face mask And the hospital, this was when this all first started, actually berated him for it, told him it would scare people. And he said he had to quit because he was, you know, he took care of his mom and he didn't want to bring it home to her. So another lawsuit that's been filed. And then there's the Walmart lawsuit that I referenced earlier. And so these cases have already been filed. So in the back of your heads, keep in mind, you want to be doing as much as everybody else is doing or even a step above. So hopefully you won't be sued. Hopefully no one will catch it. And if someone, God forbid, does, you can say, look at all this stuff we were doing. Here are some more resources that you can use that may be helpful to you in determining what's best for your workplace. All right, WARN.
Everyone's favorite topic.
I was going to say,
mine.
wake up, wake up, wake up. How much caffeine have you had? Actually, we're going to breeze through this quickly because I want to spend through the last 15 minutes taking questions. Or do we have questions?
We have two here. One I think may have already been answered, but we'll hit it again.
Let's just hit WARN real quickly, and we'll go through this, but here's what I want to say about WARN. I think a lot of people, and even a lot of law firms, have put advice out there that because COVID-19 was such a crisis and came on so quickly, that some of the exceptions to WARN will be triggered and companies will not be held responsible. I just want to say, I don't know that that's right. And I don't know that that's right specifically in every circumstance. You know, we're now well into the sucker. I mean, we're 6 weeks post most businesses closing down. We are certainly 60 days into knowing about this. And so the question of how just out of the blue this came is becoming more and more fungy. There are state mini WARN acts, and some of those state departments of labor that administer those mini WARN acts are basically saying, I don't know. And so I would not bank on it being held as a global rule that because of the pandemic, WARN isn't going to apply. So we have thrown these slides in here. And it's got the specifics as to what the triggers are. Please know that a lot of different states do have mini WARNs. It can be not just for completely closing your business, it can be for a partial shutdown as well. And if WARN is triggered, you got to give everybody 60 days notice. And somebody who may be on a furlough, who you're still paying their benefits, is covered as well. They get the WARN notice too. So all of this can add up. You got to count those folks who are on furlough as part of this. Here are the exceptions to WARN: faltering company, unforeseen business circumstances, which is what a lot of people think that COVID-19 will fall into. Just to flip backwards, I think faltering company almost applies now. I mean, there has been so much uncertainty about when businesses will open back up. It varies by state. Even some states, it varies by counties. This may well apply. Unforeseen business circumstances, again, it's getting more and more difficult to call this unforeseen, unforeseeable. And then natural disaster. Heck, I'd throw that thing in there too if I were to think of a WARN case. You know, we don't know right now if it was caused by a Chinese lab or a bat. So I'm going with bat and saying natural disaster. So it's possible, but the point of this is just keep it in the back of your head. If you are eliminating a certain number of positions, if you're getting rid of a number of people, if you're looking at closing down a significant part of your operations, check with your legal counsel to see if WARN is going to be covered. Hooters has already been sued. Hooters did a mass layoff on March 25th down in Florida and decided just to term a bunch of people. There has already been a WARN suit filed against them. Again, we'll see how it all plays out. But one of the things they mentioned in the complaint that I thought was really interesting is that Hooters could have applied for one of the COVID loans, PPP loans, and didn't, and that was not reasonable. Oh, what's the best way to provide notice if employees are not on site? You've got to provide notice to people, and if you get to that point, talk to your legal counsel. Email is obviously the best, easiest. Hopefully people will respond to you. If you don't get any response, then you sort of go to a second step, which can be certified mail, which nobody ever picks up, by the way. because you got to go to the post office, you got to sign for it. You know, you can FedEx things for signature, things like that. And by the way, WARN applies even to nonprofit companies. Is it true some states have eased WARN restrictions? Yes and no. I'm not going to go through New York and New Jersey because for most of y'all it doesn't apply. Just know, again, keep WARN in the back of your head. If you're getting rid of a significant number of people, you need to go through and see what you need to do. Okay. Do we have any questions? Or...
We have a few.
Oh, good.
We have a few. Okay. The first one, which I think we've kind of hit on, but worth talking about again because it's a little bit different. I have an employee who refuses to return to work until the CDC recommendations don't include stay at home. We are planning to reopen on June 1st. What if the CDC doesn't change their recommendations by then?
Again, dig back in, make sure that is the only reason. Make sure it's not because the employee is diabetic and therefore maybe more susceptible to a harsh case of corona. Make sure that's the only reason. If that's the only reason, then it's completely up to you. You're not legally protected by saying, I'm afraid of getting COVID-19. Does that sound harsh? Maybe it does, but I'm a lawyer. You've asked me for legal advice. That's all I'm giving is the legal advice. If your HR team decides or your management team decides we want to give them another 30 days leave, we want to keep them on for 60 days unpaid, you certainly can do that. Treat everybody in that category the same. But the truth is there's no legal protection.
We are a healthcare practice. When you're saying employees should wear, when you say employees should wear health grade face coverings, can you please clarify N95 or paper mask? Is it just the provider or the staff as well? That's a toughie.
Call me later. Call me later and we'll talk through that one. That's one that I want to have the CDC guidance specifically up because the CDC has specific guidance on healthcare and it's included in the materials. There's a link you can click on and it will walk you through far better than I can.
It appears that you're advising employers in an office setting to continue to allow teleworking by employees where possible until we have more clarity on a potential phase 3. Is that right?
Yeah. I mean, I would. I mean, if you've got people who can work from home, there are lots of ifs, okay? You know I'm an attorney, so I'm going to qualify the heck out of everything, right? So if people are working productively from home, if they're able to do their jobs, I would do that. I mean, if you need to have Zoom meetings, if you even want to have a meeting in the office where you socially distant, I would do everything I can to keep my folks safe. I would. And if people can stay at home and work, that's the safest way to keep them. If it is creating some kind of a burden on your business, talk about how to alleviate that burden. But yeah, I mean, I don't think it's a bad idea at all. I mean, obviously we are a law firm. We're not returning people to work right now. There is no big announcement. And we're an essential business, by the way. We could have stayed open and rocking and rolling in the state of Arizona. And, you know, we're voting with our feet on this one, Quarles and Brady, is we've kept our folks at home. And we have found we've gone to a skeletal staff. We do have some admin folks who are here just to, you know, get filings done that may require some kind of physicality. I've been in the office a couple of times for things like this. But by and large, we are all working remotely, and that will continue until our firm makes an assessment that it's no longer in the best interest of everybody.
We are a management consulting firm where all employees can and have been effectively working remotely since mid-March. The owner wants to get people back in the office and get back to business as usual. Says, but not for a bona fide business reason. So I'm not really sure what that means. We could dig into that. But can we require employees to return to the office without a business related reason for doing so?
Yeah, you can. Yeah, absolutely you can. This is one of those deals that it's a question of can versus should. Again, if somebody gets it, there is a possibility, this has not all been worked out, that you could be sued saying the behavior was willful and wanton, there was no real reason to return to work, and yet the company required it. I would still put in place all of the safety features that we have discussed. But, you know, talk with the owner or with whoever is saying that. There may be really valid reasons that he or she believes people need to return. I mean, has the creativity dropped off because people can't really collaborate in the same way? Has productivity dropped off because, you know, people are napping during the day or walking their dog or whatever else? I mean, if there's a substantial reason for it, try to get to the bottom of what that is, and again, document it.
If we are taking temperatures of patrons and employees entering our facility, did you mention keeping a record and documenting that information?
I don't want you to document it.
Yeah.
And I'm going to tell you why I don't want you to document it. It's because, number one, it's a pain in the neck, and it's going to be on a clipboard, and everybody's going to be able to see it. And technically, under the ADA, not under HIPAA, under the ADA, it's a medical record, and it has to be kept confidential. And so, it's not going to be one slip of paper that goes in the employee's file. It's going to be every employee with their name and just the temperature there. So I would not document it. I would document that you're doing it.
Yes.
I would document that who the manager was who was responsible for it that day. That's what I would document.
And if there's someone who's kept out of the workplace because
Yes.
they have a temperature of 104, that
Yes.
needs to be documented.
Yes.
But the point I think we were making also is if you do, or if there is any, it needs to be kept private and confidential.
Yes. Excellent point.
I have an employee that just sent me a doctor's note that she's to be out 7 days. Can I tell her she needs to stay out 10 days per the recent CDC changes?
Yeah, if she's out for COVID-19, yeah. And, it's 7 days. I have to go back. I always go back and read these things because some of them are 7 days from the time symptoms began. Some of them are 72 hours after all symptoms stopped. Yes, you can. And again, as I said, as we learn more and more about COVID-19, we're finding out that people are contagious probably before they ever knew they had it. Maybe after their symptoms have stopped, they're still shedding the virus. So yes, you certainly can say 10 days. I have employers who are saying don't come back for 2 weeks.
And the follow-up to that is that this employee has 32 hours of sick time accrued. Do we use her accrued time first, or the 10 days of FFCRA paid leave first?
You are the expert on this one. You answer this one.
I think you give the employee the option, but you can't run them concurrently. The employee would probably like to have his or her sick time first, assuming it's paid at their full hourly rate, because the FFCRA leave is at a reduced rate. So I would give the employee the option of what they want to use.
Yeah, it's much easier. In Arizona, we have this mandatory employer paid sick leave act. And employees have a lot of discretion how they use it. And so it's always best, and we advise employers, ask the employee, because as Lindsay said, most of them are going to want the dough.
And to your point, you can't require anybody in Arizona who's using, who has paid sick leave, you can't require them to use it. So you are always better off offering them that choice.
Good question.
Yes. Okay. Oh, sorry. Here I go. I should have been marking them done as we went through. This same employee's hours were cut to 32 hours, as all employees were. So are we still paying her the 40 hours per week of sick time, or is it the 32?
The calculation is done based on the last 6 months.
Yes.
So average it out last 6 months. That's how the calculation is done. Oh my gosh, wow, a math one and I did it.
I think that's all of them. I know you all have more.
Send in some questions. I'm gonna I prepared this list of questions I've gotten from clients. If any of you have unions, first of all, bless your hearts. Second of all, you need to bargain with them over a lot of this. So please don't forget that. Regarding gloves, there's been a lot of guidance that regular hand washing is more effective than gloves. What are our thoughts on this? Hand washing is awesome because gloves do get grody and grimy. But again, it really depends. And some of this too, I hate to say it's a placebo, but it is. I mean, if you have employees on the front line, if you are a grocery store, if you are someplace where people are interfacing with the public, they may feel safer wearing gloves. And so I would give a lot of deference to an employee feeling that way, but I would make sure people understand that, they're wearing these gloves and then the gloves are contaminated once they have been working with the public. And so, give them instructions. There are videos out there on YouTube on taking them off and throwing them away and then going and washing your hands. Those are really important things to make sure you're educating employees on.
Another question about temperature testing. Do you have to keep a record of it? And
No.
I think, no, you do not. And that's sort of what we're saying. Maybe you probably don't want to, but you do want to keep a record of an employee.
That you did it.
Yeah, or someone tests
yeah.
positive, right? Or
Yes.
has the over 100 degrees
Yes.
fever. Also, just worth mentioning, even though we're not scientists here, just because someone doesn't have a fever doesn't mean that they don't have COVID-19.
Right.
So it shouldn't be the only thing that
Right.
you're considering.
Right.
That's my little plug. I'm very preoccupied with everyone's safety. With workplaces reopening, aren't we likely to see that it's very difficult to procure masks and other supplies? Is the advice not to reopen until those supplies are in hand?
Again, I have been to law school, so I can answer every question. It depends. I don't know how difficult it is to get decent masks. I know that right next to my dry cleaner is an alterations place that is selling masks. That's all we're talking about. We're not talking about medical grade masks. We're talking about masks. Literally, my neighbor made this. You may note it says Harry Potter on it. I bought it for my son. He's in high school. He told me he was humiliated. It's now my mask.
I made my own from, and it's not even sew it. It's just a way to fold a bandana and put some hair ties on it. And there are lots of YouTube videos on this.
Yes.
So there are ways to do it without being all official like.
That's what it is. And I love this, and maybe this is a good way to end this seminar. Probably not, but for those of you who know me, you know I have a bizarre sense of humor. But you know, masks are not for the protection of the person who's wearing the mask. The mask is largely for everybody else out there, that if you have it, this prevents you spewing junk out there that other people are going to breathe in. And there's some really cute things, some really cute memes about, you know, how pants protect us against people who pee their pants who we're sitting next to, because, you know, the pants absorb some of the pee, and then your pants protect you to the extent there's any pee that wasn't absorbed. I'm sorry to have to go there, but yeah. So
we are employment lawyers,
yes.
So this is standard discussion for us.
Yes, bodily fluids is part of the job. But that's what we're talking about with masks. And so, yes, can you go into CVS right now or Walgreens and buy a box of masks? No. Can you go to the alterations place right by the cheap dry cleaner on 7th Ave, Missouri, and get as many of them as you want for $5? Yeah. So see what you can do with regard to those kinds of masks. I hope that answered your question. Are there any other questions?
I think we're good, and we're 1 minute over, but
one more.
This is a landlord-tenant question.
Oh, that scares me.
Yeah.
Whoa.
But we can, if you want to email us separately, we can see if there are folks in our office who
yes.
can help.
We have commercial litigator folks who are doing everything with landlord-tenant and leases because we are aware that there are laws in place. There are some regulations from our governor and regarding being able to cancel leases or evict people. And if you've got one of those questions, email it to us and we will get it to the right person for an answer. Thank you very much for joining us today. Again, please do fill out evaluations. We read them and we try to customize our future presentations to what you really want to hear. Thanks a bunch and we'll see you next time.
Thanks, everyone.